It wasn't until I was a law student and became a lawyer that I ever heard of these curious terms: thin skull plaintiff or eggshell plaintiff. And essentially what it means is that if a plaintiff has a particular weakness or susceptibility and they are hurt and they suffer more as a result of their weakness or susceptibility, it doesn't matter, because the defendant, the party that is sued, takes the plaintiff as he or she finds them. And that little expression, takes the plaintiff as you find him or her, means essentially that the eggshell plaintiff, the thin skull plaintiff, is entitled to the full measure of their damages, even though they had a particular susceptibility. I was looking at a law textbook the other day, and I happened to come across the following sentences: A's bad luck at bumping the one individual vulnerable enough to suffer serious injury does not protect A from liability. And that is the basis, that is the standard that we have followed in law, and it is very much, of course, a part of the Massachusetts tort system or the Massachusetts law. So those curious terms, it may not be a head injury, but it clearly could be something else that a person is more susceptible to suffering than the average. And that person, at least under a strict legal interpretation, should feel that he or she will get the full measure of his damages, regardless of any personal problem. Now, this should not be lumped together and confused with what we've often talked about, and that is pre-existing conditions. The pre-existing condition law, or use of it by insurance companies, is to say that this person was affected in a bad way by a prior injury or condition, and therefore they argue, and the law does support this, that they, the defendant, is only liable for the exacerbation or aggravation of that pre-existing condition. And of course, there's a huge amount of dispute and a huge amount of contentiousness over what constitutes an exacerbation or an aggravation. I will also point out that sometimes we're dealing with a situation that was previously asymptomatic or dormant, wasn't giving the person any problem, and it gets triggered by the tortious or negligent conduct. And in those cases, the plaintiff should get not the aggravation, because we're not dealing with an aggravation, but should get the full compensation for the triggering of that condition. That too, obviously, is a very contentious point, but I feel that I have given an accurate statement of the law, and how it plays out, once again, depends on the facts and the presentation of every case. Thank you.